Hello, and welcome to the League of Women Voters of Portland's Voter Forum for the election to Position 2 of the 4th District, Multnomah County Circuit Court. I'm Chris Kobe, member of the Portland League and the moderator for this forum. The League is a nonpartisan organization dedicated to making democracy work. We believe democracy works best when voters are informed about the issues and engaged when their communities. We're presenting this forum to give eligible voters the opportunity to learn more about these candidates. We are grateful for the support from the Carol and Velma Sailing Foundation, the Weiss Foundation, the League of Women Voters of Portland, and our media partner, Metro East Community Media. The 4th District of the Circuit Court covers all of Multnomah County. All county voters are eligible to vote for candidates for this office. All candidates for this nomination were invited to participate in this voter forum. All candidates accepted and are here today for the forum. In alphabetical order, they are Chris Baer, Judge Juliette Britton, Annette Jindal, Laura Maurer-Rowan, and Diane Sykes. Welcome to all the candidates, and thank you for participating. Under the voter forum standards for this event, each of the speakers will give a 1-minute opening statement, followed by questions we have prepared based upon league positions and league members' interest. Each speaker will have a 2-minute closing argument. Each speaker will have up to 60 seconds to answer each question. To determine the order in which the candidates will present their opening and closing statements and answer questions, we use the Oregon Secretary of State's current and previous official candidate random alphabets drawn in every election cycle. Judge Britton will give the first opening statement. Judge Britton, please proceed.
Thank you for this opportunity. I'm Juliette Britton. I have been the presiding judge at one of the busiest municipal courts in Oregon. In my capacity as Beaverton's presiding judge, I have presided over thousands of criminal misdemeanor cases, conducted settlement conferences, and presided over jury trials. I've also, other than the routine criminal matters, have created several unique programs and created several firsts for municipal courts, including creating a mental health liaison embedded in my courthouse, creating a mental health court, as well as a nationally recognized drug treatment court. My background started in the United States Army as a judge advocate JAG attorney, where I prosecuted and also defended defendants and soldiers who were accused of crimes. I have significant leadership experience. I've run 2 government entities and not-for-profits and come with over 16 years of Oregon mental health and addiction experience. Thank you.
Thank you, Judge Britton. Mr. Baer, please proceed.
Thank you. My name's Chris Baer. I'm a public defender. I have worked for almost 25 years in public service. My desire to become a judge started at a very early age. I was in elementary school when my dad, who was struggling with schizophrenia, applied for Social Security disability. I watched him get denied over and over, and I know the impact that a judge can have on a struggling working family, because when he was finally seen by a judge and seen as a human being and granted his benefits, it changed my family's life. It propelled me into law school. It propelled me into a career of public service. I've worked as a legal aid attorney for a decade. I worked doing civil type cases for survivors, mostly of domestic violence. And now I've done 13 years of criminal defense. I'm prepared to start on day one for any kind of case.
Thank you. Mr. Jindal.
Thank you. My name is Annette Jindal. I'm a father, Portlander, and attorney. I'm a partner at Markowitz Herbold, where I've been for the past decade. I represent clients of all shapes and sizes in civil litigation matters. In my practice, I represent plaintiffs, defendants, individuals, businesses, and government officials. And I've had the privilege of working on some of the most important legal issues affecting our community, For instance, I was proud to be part of the team that defended the Reduction of Gun Violence Act, Measure 114, in state and federal court. That law was designed to reduce gun violence and save lives by limiting the magazine capacity and creating permitting requirements with background checks and training for firearm purchases. In court, our team demonstrated that that law was consistent with the Second Amendment. I've also represented clients in a whole host of other areas, including other constitutional law issues, securities law, trade secrets law, contract law, property law, just to name a few. I'm running to be a judge because I believe I have the breadth of experience necessary to tackle the hardest issues in our state's busiest trial court on day one.
Thank you. Ms. Sykes.
Hello, Diane Sykes. I'm running for Multnomah County Circuit Court Judge because I believe that I have the depth and breadth of experience as a seasoned practitioner. I have been practicing law for 28 years and it spanned the gamut of areas of practice. I was a public defender starting out. I was a legal aid lawyer for 10 years, serving primarily immigrant populations, and then went to DOJ, state DOJ, to set up a civil rights unit, the first for the state. After setting up the civil rights unit, I opened up a private practice where I've been for the last 13 years litigating civil rights cases on behalf of workers, primarily. I want to be a judge because I believe that I can effectively step into the job and immediately take on the casework. I'm accustomed to working in high volume case settings, and I can handle the criminal and civil docket and look forward to serving the people of Multnomah County.
Thank you. Ms. Rowan.
Hello, I'm Laura Maurer Rowan. I am from here and I returned here for law school. I've been serving the public in public service law since I graduated. I started my career in the Multnomah County District Attorney's Office. One of my proudest accomplishments there was to be tapped to serve as the county's first mental health deputy district attorney. In that role, I staffed and handled every single case in the county that had a mental health component, which required a lot of collaboration among system partners and people within the criminal justice system. I've also worked with victims and survivors of human trafficking and domestic violence. I've tried many cases from misdemeanors through murders. I've also worked in the civil realm at the Portland City Attorney's Office and now currently at the Oregon Department of Justice doing post-conviction relief cases and appearing before the Psychiatric Security Review Board. With my background and familiarity with Multnomah County, I am ready to return to the courthouse to serve the community that I love.
Thank you. That concludes the candidates' opening statements. Our first question goes to Ms. Sykes. What, if any, role can a circuit court judge play in the treatment of the homeless as parties, witnesses, or jurors in our courts?
The court should be accessible to all litigants, witnesses, and jurors. Homelessness should not be a barrier or challenge to serving. The court should make sure that the avenues for service are available. That can be challenging, let's say, for jury service where someone doesn't have an address, and finding alternative means to communicate and make sure that there is a safe way for people to come into the courthouse and participate. The court will contend with the challenges faced by those who don't have shelter and housing, and that will be a part of the docket that the court will have to consider, as well as in criminal matters, whether homelessness is a contributing factor to the criminal conduct, to recidivism, and offering wraparound services to prevent that cycle to the degree that it's possible. Everyone should have access to the courthouse, no matter what their status.
Thank you. Ms. Rowan.
Thank you. I agree that everyone, regardless of status, deserves equal access to our courts. People experiencing homelessness do face additional obstacles, transportation, ways to record dates and times, ways to communicate with their attorneys or with the court if they don't have access to phones or email. I think that the court can help assist those individuals by making sure court dates, to the extent possible, are set in court with the person present, make arrangements with the person while they're appearing before them about how they can get to court at the time that they are scheduled to be there. It's very important that our jurors reflect the cross section of our community and are included in the civic practice of becoming a juror and serving in that manner. And so I think that courts can assist and should, to make sure that it's fair for all participants in our community.
Thank you. Mr. Chindle.
Thank you. I'll echo what my, I want to say colleagues, but I guess opponents have said. All individuals with business before the court should be treated fairly and have access to the court, including those of limited means or people with difficult housing situations. And as a judge, I'd strive to ensure that no one has their access to the courts disrupted because of their housing situation. And most importantly, no one's discriminated against in their cases because of their housing situation. That said, a lack of a stable address can present some case management issues for individuals out in the community. As others have mentioned, making court dates is hard if you aren't receiving notices, and there are ways that judges can help alleviate that. But as a judge, I will work to ensure that courts are accessible to everyone with business before them. I will say access to justice is an issue that's important to me. I'm the vice president of the Multnomah Bar Foundation, which is dedicated to breaking down barriers for access to justice in the courthouses here. One of the ways we do that is by funding Court Care, which is a free drop-in childcare that's available to people with business before the courts. That makes it so that something like childcare needs doesn't ever become a barrier to someone coming to court.
Thank you. Judge Britton.
What my colleagues have all said, absolutely access to justice for every individual who either is doing business in the court or has been invited, like a juror, to come to court. We need to make sure that our often, or I should say historically, inflexible courts have a different approach these days. You know, many individuals do not have a permanent home. They might be couch surfing with varying address changes. And so it's incredibly important to make sure that we have alternative ways that we can communicate with jurors and litigants. In my court, we had to deal with this firsthand during COVID when our courthouses were closed. We never before had used email. We implemented an email. We implemented leaving the dockets on the window for those that came in person. And it's important to have judges who are open to change and are willing to advocate for change if it means increasing access to justice.
Thank you. Mr. Baer.
Thank you. I have spent my career, the bulk of my clients having some level of instability. Often it's houselessness that is a large barrier to either getting justice because they're a victim of crime or having their day in court properly because they're accused of a crime. I have to say that the alternatives to the criminal system, such as treatment courts, where resources are brought from the community or from the state level to a program like a treatment court, often includes a residential component, and it can make a massive difference in someone's success in the program. The mental health court specifically, that Judge Waller, currently the judge in seat 2, they make it a point to ensure stability through shelter, stable shelter.
Thank you. The next question is, what reforms, if any, would you like to see in criminal sentencing? And we'll start again with Mr. Baer.
I'm sorry, did you say Mr. Baer?
Yes. Mm-hmm.
Wonderful. So sentencing reform is essentially a legislative question. As a judicial candidate, the code of conduct conduct restricts us from making promises or pledges regarding political positions or any potential controversies that could come before us. That said, I have been a staunch advocate for, treatment courts, alternative sentencing. As a public defender, I have to deal with the debris of mandatory sentencing, and it would probably be a struggle if to have to hand out mandatory sentences to first-time offenders who are young, who have, their own overwhelming life circumstances. Obviously, I would follow the law, but it would be the most difficult part of the job.
Thank you. Judge Britton?
I agree with Mr. Bear that we should be expanding our targeted specialty programs that address root cause issues. I think that treatment should be available no matter what the sentence is. So whether somebody's in prison, jail, or out on probation in the community, they need to get the services they need if we want to stop and lower recidivism. I will say, as a judge, you'd think that I would want more discretion, but the longer I do this, I see the value of consistency and predictability in having sentencing guidelines and standards. Measure 11 was voted in by the people, and I respect our separation of powers. And if that is what the law is, I'm quite comfortable following it. I think that it reduces judge biases, whether it's positive or negative biases from coming in when you have guidelines and standards. And even beyond Measure 11, we see it in probation cases, Dewey's, for example, where there's very little discretion for judges. And I think that should be a legislative branch directive.
Thank you. Mr. Jindal?
Thank you. I also want to echo that I want to be mindful of the role of a judge is to apply the law as written, not necessarily change it. But one thing in this area that I've been concerned about in recent months is the way that countywide funding issues have threatened to limit release services for criminal defendants. It's not directly a sentencing issue, but it does lead to longer periods of incarceration. I'm aware that there are two programs, so pretrial release services and Close Street, that have been threatened with funding cuts in this most recent round of countywide budgeting. These services are intended to supervise criminal defendants while they are out in the community pending their court dates. These are valuable programs that ensure our jail beds are reserved for individuals that pose the highest risk upon release, while also ensuring that defendants who can safely return to the community with specific supervision are able to do so. I'm hopeful that these funding decisions will continue to be discussed and that we can continue to prioritize these valuable programs that keep folks that aren't needed in jail out of jail.
Thank you. Ms. Sykes?
We as judges aren't allowed to make policy decisions. Agreed. We have to uphold the law as written. There are certain sentencing guidelines that allow for mitigating circumstances, and that is something that judges should look to in the scope of addressing criminality and in sentencing, where public safety can be assured, providing other alternatives such as work release programs or diversion or community service, wraparound services in order to divert people out of the court system who don't pose or the jail system that don't pose a risk to the community in the effort to avert recidivism. The sentencing guidelines can also be reviewed. There is a coordinating committee through Multnomah County that's represented by judges, DAs, defense attorneys, community service organizations, parole and probation that can talk about sentencing reforms and evaluate that holistically under the circumstances.
Thank you. Ms. Rowan?
Thank you. As others have already mentioned, sentencing reform is the role of the legislature. And as a judge, I would enforce the guidelines as the legislature intends. Of course, those do leave some room for discretion for the courts. And I think that the courts do need to look at each case individually and use that discretion wisely. When I was in the district attorney's office, we often, on more serious cases, especially felony cases, we would utilize the pre-sentence investigation reports prepared by probation and parole. Those would allow the judge to have a much bigger picture view of the person's history, what led them to the criminal justice system, and therefore design a sentence that was more specifically tailored to that person, whether it be resources or a determination of where they should fall within the sentencing guideline prison sentence. And I think that that practice needs to continue, as well as the evolvement and development of alternative courts.
Thank you. The next question goes again to Mr. Baer. What, if any, weight should voters give the number of a judicial candidate's financial supporters, the identities of their donors, and the amount of the average contributions? Mr. Baer?
So the voters will obviously be interested in any potential like conflicts of interest or influence, and I'm glad that our system allows for transparency in that. There may be some weight to a candidate's overall ability to forge relationships within the justice community. They can look at grassroots level of contributions. I have the honor of having well over 100 contributors, but I've been pretty modest in my raising. I do think that it's important, though, for the voters to be informed at every level about everything that a potential public figure could be influenced by.
Thank you. Judge Britton.
Agree that transparency is important for the voter at a time when our judiciary has the lowest level of approval rating in the history of the United States. I think it should cause us to pause on whether or not we should allow these sort of things. I mean, there is some could view and not only endorsements, but donations, that then the judge would be beholden to the particular policy perspective that the donor has. I, for one, am quite uncomfortable taking donations, particularly from attorneys who might appear in front of me, and have really instead focused my campaign on meeting with voters rather than focusing in on endorsements and donations for that reason.
Thank you. Ms. Rowan.
Thank you. I also agree that transparency is important. I think judicial races are unique because they are nonpartisan. They are not political. Voters rarely get to decide since most of these are resolved by appointment. I think to the extent that voters look at and care about who and how much people are raising, it can demonstrate a certain level of support or trust that the community at large has in a certain candidate. But as judicial candidates, we are bound by the ethical code, which does not allow us to ask for money personally. And so that should demonstrate that no one who receives money from any particular individual or organization would be beholden to them, since they should not be having any direct conversations with potential donors about fundraising at all.
Thank you. Ms. Sykes.
It is unusual in a judicial race or to have a judicial race in the first instance. And with that comes the need to, fundraise for the purpose of getting the word out. But with that said, it is important to be mindful of the source of donations and the quantity of those donations. And I think that my campaign reflects that there are a large number of smaller donors who have worked with me, whether on the defensive side or on the plaintiff side. And I think that is what more indicative is the endorsement process. I would absolutely support reforms so that in the future judges don't have to, that there will be some kind of campaign finance reform or changes to the requirements so that judges who are neutrals don't have to curry support from people in order to serve on the bench and serve the community.
Thank you. Mr. Jindal.
Thank you. I agree that transparency is important, and the voters are right to scrutinize the fundraising efforts of judicial campaigns. The information's public. It's on the Secretary of State's website. I'm proud to have raised the money that I have, or not me personally, but I'm proud that my campaign and that people have donated to me are mostly consisting of family, friends, colleagues in the legal profession, people that have worked with me, plenty of people that have worked against me, all of whom I assume believe that I would make a strong judge. And so I think that the voters are right to look at that information, and it's all public, and I encourage them to do so.
Thank you. You are watching the video of the voter forum of the League of Women Voters of Portland, or listening to our podcast for the candidates for position 2 for the 4th District Circuit Court, which is Multnomah County. Our next question is, what, if any, changes in the Oregon jury system or jury service do you think should be considered? And we'll start with Ms. Rowan.
Well, Oregon recently came into line with the rest of the country in requiring unanimous jury verdicts in 2022 with the Watkins decision as a result of the Ramos U.S. Supreme Court decision in 2020. So I'm proud that Oregon is now in the company of the rest of the country. As for jury reform, I believe, as we said before with the sentencing reform, any jury reform would need to be decided by the legislature. However, as I stated earlier, I do believe strongly in the Sixth Amendment right to a fair and impartial trial. And that requires a jury, we say a jury of one's peers, but a cross-section of the community. And we need to increase representation among our jurors to align with the people who are appearing in court. So I would support any initiatives that did further outreach to diversify our jurors so that they are adequately reflective of the community we live in.
Thank you. Mr. Jindal.
Thank you. Juries are the bedrock of our judicial system. They're private parties that we, ask to serve their community and decide some of our hardest and most pressing issues. And I think it's a cliche to think that everyone always wants to get out of jury service, but it is a problem. And I think that fundamentally, the biggest thing that we as potential judges and actual judges can do is be out in the community talking about the rule of law, talking about the role of the justice system, and ensuring that people really know the great public service that they're doing when they get that little card in the mail and they come to the courthouse, and that it isn't just this annoying thing that you've got to do with your time and you have to try and get out of. And I think the way that we do that is by talking to people about the role of juries in our system. I've mentioned this, but I'm on the Multnomah Bar Foundation. One of the things they do is send judges out to community groups to talk about the rule of law and to talk about our court system in particular. I think that has a great effect to make sure that people don't see us as these people that are on a podium. We can come out into the community and talk one-on-one about the importance of jury service. And I look forward to doing that myself as a judge.
Thank you. Ms. Sykes.
I am impressed by the diligence and willingness of jurors to serve over long periods of time. I think that we can make the system far more accessible and attractive to jurors to make them available if we do a number of things. One being notice in advance. If a juror is going to be dismissed, a juror is not needed, giving them advance notice so they can arrange their schedules accordingly. We need to look at payment of jurors to make it not as much of a hardship for people to come in, forego work, childcare. I believe that court care, allowing for childcare for those who have childcare needs is going to be important. I believe that it should be more of a common practice for jurors to be able to ask questions that keeps them engaged in the process, to be able to take jury instructions back into the deliberations to review those, to have interpreters be available for monolingual non-English speakers so that they can truly participate in the process. And, when needed, jurors are going to need to be excused if they are experiencing a hardship. But I'll stop there. Thank you.
Thank you. Judge Britton?
The single most important reform we can do is raise the jury fee reimbursement rate. This is absolutely the number one reason that people are requesting excusal in advance of serving as a juror, is that they are hourly wage workers and they cannot afford their rent or food or childcare if they miss work because they won't get paid their normal wage. And so absolutely increasing that, I think, will bring in more diverse jurors. I think Ms. Sykes makes an excellent point. We should be examining our jury questionnaires to make sure that it's inclusive. When I came to my court, we weren't asking on the jury questionnaire whether you needed an interpreter. And I changed that. And now we have interpreters available for any juror of most languages that want to serve on the jury. So I think as judges, that's where we need to be constantly open to change and review and make sure that business as usual aren't creating barriers.
Thank you. Mr. Bear?
Thank you. So I'm glad that Juliet brought up the payment issue, because that is, obviously basic access, basic language barriers and childcare, all of those things are critical for jurors to have a meaningful ability to participate in what I think is not just a bedrock, but sort of the last bastion against tyranny. Like the courts, as we're seeing in today's timely issues, are so critical in our democracy. And if working people cannot afford to participate, then this is not a real cross section. This is not what all the way back to the Magna Carta is envisioning for jury service to look like. We need to have real judges who can understand what working families need to participate. We need them to feel welcome, and we need them to feel like this is a dignified position to participate in.
Thank you. Our next question goes to Ms. Rowan. What, if any, objective public quantitative information is available to voters to assess the performance of a circuit court judge? If you are not aware of any such information, should such information be available to the voters, and what would it be?
I don't think that there is any publicly available quantitative data to support the performance of a judge. They don't answer to a particular agency. I think that you can determine whether or not a judge is trusted and well-liked based upon the legal community's response to that court assignment. The news coverage obviously will also inform voters about whether or not judges are following the law. You can determine whether or not they're making the right rulings on legal decisions based upon the reviewing court's agreement or disagreement with appeals related to those rulings. I think a public forum or clearinghouse of data that would support or capture data about a judge's performance could be dangerous because of who would be in charge of collecting that data. It could be somebody who felt that they were, didn't like the ruling that they got. So it would need to be very balanced and impartial, and I'm not sure of a way to accomplish that with the tools we currently have.
Okay, thank you, Mr. Jindal.
Yeah, I think that transparency and the ability for the general public to evaluate how their judges are doing is important. One thing that the general public can see is the reversal rate of a judge. They can see how frequently the Court of Appeals or the Supreme Court is reversing their decisions when those go up on appeal. I don't think that information is compiled anywhere, but it's publicly available. One thing the federal courts do that I haven't seen in the state courts is they actually keep a list of motions that have been pending for, I think it's at least 6 months since they were submitted. And there's just a list that's publicly available for every judge and every motion that has been pending for that long. And I know from practicing, judges don't like to be on that list. And you will see that when that deadline comes, there's just a flurry of activity on the federal cases. And so I think, and then it happens both at the trial and the appellate level. And so I think that, we haven't implemented something like that in the Oregon state courts, but it's something that other courts do that might be effective.
Thank you, Ms. Sykes.
Various professions have feedback measures, whether it's a doctor, lawyer, other professionals. I believe that, as my colleagues have said, that there isn't any established system. So one that is legitimate and verified and authentic to be able to provide that feedback can be helpful. It shouldn't just drive the decisions that are made from the bench, but it can be important information for the judiciary to consider in being more transparent and effective. Appellate reversals can be an indicator or a valuable source of data. However, judges need to make their decisions based on a fair application of the law, upholding the rule of law. And if they're wrong, thankfully, we have a system that will hold that decision, will correct the decision if it's not made. So there are ways for people to evaluate judge performance, but I would support a feedback loop that gives further information to judges.
Thank you. Mr. Baer.
Thank you. There is an inherent sort of tension between the desire for there to be transparency and for there to be public sort of democratic oversight. And we do have enshrined in Oregon the electoral system for judges every 6 years. There's not a formal system to maintain data. The tension comes from the role of the judiciary being independent from popular opinion, in essence, because they have to protect individual rights, and individual rights aren't always the most popular thing. And so it's tricky. I was part of a program, a nonprofit program when I was in legal aid called Court Watch. And, that allowed people to come into the court, assess the data, and provide it to the public. And I would support a legitimate nonprofit organization that ran that.
Thank you. Judge Britton?
There is statewide statistics on the Oregon Judicial Department website that tells us how many unrepresented defendants there currently are on any given day, how many cases filed, the type of cases, and how long those cases have been pending, which traditionally, having a case open outside the reasonable best practice metric is considered a bad thing. So there are ways for voters to look and see, is Multnomah right now getting it right? And they can see maybe what skills they might want in a judge to go in and potentially help fix some of these issues. Multnomah continues to have unrepresented defendants where there's no attorneys to serve them. Multnomah continues to have cases open longer than the Oregon Judicial Department's timelines. And they need efficient judges that are familiar with criminal cases. That's 85% of the cases in Multnomah. And, voters can potentially use those metrics to make their decision.
Thank you. Thank you all for the responses to those questions. The candidates may now provide their closing statements, with Judge Britton going first.
Thank you again for this opportunity. I think Multnomah is very lucky to have such a wealth of experienced attorneys who are interested in serving on the judiciary. And as somebody who's currently in the judiciary, it just really pleases me that we have such great attorneys here. I am the only candidate that has judicial experience. I've been a full-time municipal judge for the last 8 years. I've developed programs. I'm not just talking about the programs or just talking about how I think the system should be improved. I've actually implemented innovative practices and procedures in my own court. I could hit the ground running on day one. I have a background primarily in criminal experience, both as a prosecutor and defense attorney, but I also have a wealth of experience as a nationally recognized treatment court judge. I could pick up any of the specialty treatment court programs. I've presided over hundreds, if not thousands, of cases where defendants with mental illness are unable to aid and assist. This particular position is being left by Judge Nan Waller, who has nothing but the mental health court docket and the aid and assist docket. I feel quite comfortable if the presiding judge were to assign me to her docket, I could step in day one and continue that legacy that she has left us. I think as a veteran, I could potentially bring information to the bench about veteran-specific issues. I'm very familiar with the VA system as a recipient of their services myself, and feel quite comfortable in getting creative in terms of how we should support our justice-involved veterans. Thank you.
Thank you. Mr. Baer.
Thank you. I really appreciate having the opportunity to do this. I want to say that having almost 25 years of legal experience, I've only represented folks who are, unable to pay for legal representation. I believe that is a calling that I've had since very young, both in my legal aid days. When I was representing survivors of domestic violence, I got to have the perspective of representing directly victims of crime. And I got to have, from very early on, the experience of dealing with people in trauma, in crisis, and in need of access to the courts. On the flip side, after I went out to be a judge towards the end of that first decade, I was told I needed to get more criminal experience. I had managed to pro tem, or sort of temporary judge, for about 6 months, some juvenile cases, and knew that my calling was to be a judge ultimately. And so I followed those directions. I became a public defender, and I've increased my criminal experience by taking on low-level simple misdemeanors to very complex felony cases, obviously jury trials. And then the last 6 years, I've focused on treatment courts, which I think are the future model for resolving cases in a compassionate and effective way. My workload, my work ethic as a public defender is critical for meeting the needs of a judge in a community this size, and not only the workload, but also the complexity of the cases. I can step in, and I will not be shocked by the actual duties that the judgeship requires.
Thank you. Mr. Jindal.
Thank you. Over the last several years, the Multnomah County Circuit Court has lost several judges with complex civil litigation experience to other judicial appointments or even retirement. Meanwhile, there's been a backlog of cases on both the civil and criminal dockets. I believe that I am the candidate best suited to help fill the gap of complex civil litigation experience on the court. As I've discussed, I have had a wealth of experience representing clients in commercial disputes, in complex constitutional issues, individuals, and things like family trust disputes or even property disputes. I think that diversity of experience will make me an impartial decision maker that can hit the ground running and start taking on the diverse caseload that a Multnomah County Circuit Court judge has. I also have a demonstrated commitment to access to justice. I think we've all discussed the Multnomah Bar Foundation today, which I'm the vice president of. I'm also a recent past board member of the St. Andrew Legal Clinic, which provides low-cost family law services to people in need. My work has also touched on some of the most important legal issues facing our community and even our country. I mentioned in my opening that I helped defend a gun violence prevention statute in federal court against a Second Amendment challenge. I've also represented states and cities in environmental litigation against alleged polluters. Later this week, I'll be presenting at the Oregon State Bar on Oregon Sanctuary Promise Act, which limits local officials' participation in federal immigration activities. I wrote the bar book, or co-wrote the bar book, on the relationship between the state and federal courts. I am ready to tackle the most pressing issues facing our state's busiest trial court on day one. And I think I have the breadth of experience and the diversity of experience to be an impartial decision maker, read the cases, listen to the parties, and reach fair and impartial decisions.
Thank you. Ms. Sykes.
I've practiced, as I indicated, for 28 years and have the broadest range of experience in the candidate pool. I have done the criminal work. I am familiar with the criminal docket and the civil docket. I can handle both. And I've spent my career handling high volume caseloads and will be able to efficiently and effectively address the court's greatest needs. My career has focused on representing the most underserved and vulnerable populations across the state. My focus has been to litigate in Multnomah County at Multnomah County Circuit Court. And I believe that my breadth of experience, years of experience, and the goodwill that I've created in the state and in this county speaks to my ability to take on this work and do it well. I will be able to jump in and take cases and be on the ground running to be able to do that. And I will bring a perspective that is broad-based. I am bilingual. I believe that that will help me to be able to create an inclusive work environment, court environment for people who may first have not come into the court system. And my goal to be to reflect positively on the bench and in the community, because it is the case now that people have developed some skepticism towards the balance of the judiciary. After having reviewed thousands of cases over my lifetime, balance sets in because I have to critically look at cases. I can't take every case that comes in the door. So I have to be critical in selecting cases. And with that is reviewing the facts, applying the law, and seeing whether I can meet my legal burden. That is an exercise that I do day in, day out, have done for 28 years. And that's a skill set that lends itself to the role of a judge, because I will come in with an impartial, balanced, and fair approach to this work. And I am committed to the rule of law, not bringing any personal bias into the work. And I believe that my work history has demonstrated my ability to do this job.
Thank you. Ms. Rowan.
Thank you. Thank you for having us all here today. It's really nice to have this opportunity. I have been practicing in Multnomah County primarily for the last 15 years. I've spent my entire legal career committed to public service. I'm deeply involved in this community because it is the community that I live in, that I'm raising my family in, and that I participate in. I have worked in the Multnomah County Courthouse, and I can tell you it is its own animal. People describe the caseload of Multnomah County court judges as drinking from a fire hose, and I can explain and defend that I have drunk from that fire hose. I started my career doing misdemeanors and then went into more specialized work to include the mental health deputy role, where I was piloting that project, which then became a permanent position within the office. And in that role, I was working with people from across the spectrum trying to solve a larger scale problem. And I really learned the value of collaboration in that role to try to all find to reach a common goal. I have been involved in the criminal justice system on a granular level. I have been in homicide scenes. I've been at autopsies. I have been at high school assemblies teaching about the symptoms of grooming for human trafficking. I have educated parents and teachers about intervening with relationships that may be grooming in nature. I have taught at sex buyer accountability programs, teaching buyers of sex about the dangers and harms of the human sex trade. I have taught every single police officer in the city of Portland the legal rules and requirements of cases. I've done all of the legal training for the Portland Police Bureau. And then now I do civil practice defending the work of public defenders when they later have claims of ineffective assistance of counsel. I am ready to serve this county's courthouse on day one based on my experience there and elsewhere.
Thank you. This concludes today's voter forum with the candidates for position 2 for the 4th District Circuit Court, which is Multnomah County. We thank the candidates for their participation. Audience members, please share this forum recording and podcast with your family and friends. We all need to be informed voters. If you are registered to vote by April 28, you should receive your ballot by May 6. As with all Oregon elections, almost all voters will participate by mailing in their ballots only, although in-person voting is available. Check your Multnomah County voters pamphlet either online or when the paper copy arrives by mail at your household. Ballots will be mailed starting April 29. To be counted, ballots must be postmarked by Tuesday, May 19, Election Day, at 8 p.m. The League of Women Voters strongly advises that if you are going to return your ballot by mail, you mail it at least 1 week before Election Day. That is by Tuesday, May 12. You can also find an official ballot drop box location near you by checking www.vote411.org or in the Multnomah County Voters Pamphlet. If you drop your ballot in an official ballot drop box, you have until 8 p.m. on Election Day to do so. The League of Women Voters is a nonprofit, nonpartisan membership organization. We hope this forum was meaningful for you. We welcome you to join the League or contribute to the cost of these services at lwvpdx.org. This is Chris Kobe for the League of Women Voters of Portland. Thank you for watching and listening, and for being an informed voter. And remember, your vote counts.